Yes, please.
This is from motion on 10. This is regarding
Yes.
My lord, I am also mentioning two petitions for admission, my lord. One for 10th and another for 13th.
10th not possible admission. You choose any other date after that.
13th, my lord.
13th. Yeah.
May I please your lordship? May I please your lordship? A transfer matter, your lordship. If time permits, your lordship. Can it be today?
No, today you can mention before the other bench. I'm traveling. I have to rise early.
Then Thursday, your lordship.
Yes.
My lord, good morning. My WPC number 35123 was fixed for 1st March, but not listed, my lord.
Okay. Give her the number.
So,
She'll check up
may
what
I-
has happened. Give her the number. She'll check up.
Okay, my lord.
Find out why it has not been listed.
May I
Yes.
please your lordship? I beg to mention for listing of a matter, lordship.
Hmm. Yes.
WPC 6679 of 2020.
Listing for what?
We have challenged staff selection
No, you want the matter to be listed for what?
for admission.
For admission. What is the urgency?
We have challenged a selection.
No,
process and,
I'm not asking what you have challenged. I'm asking what is the urgency?
appointment has been held, lordship.
Appointment has been
Held.
appointment. I have not understood anything. You reformulate your question and come back. You reformulate, then we'll see. Or you can approach the registered bench and make a request to him. Okay? Yes. Yes. Yes.
Your lordship, I beg to mention item number 2 and 30. My senior is out of station.
2 and 30.
Kindly pass over the matter only for today.
30.
30, yes.
Yes. 2 and 30. Passed over on the request of learned counsel for the petitioner. Same order. Yes.
Lordship, in item number 2, lordship, there is a contempt matter, lordship.
Yes. Item number 2, there is he's already left. This is not the way.
Sorry.
When the court is still in the matter, you should not walk out. There is some basic courtesy you must learn.
Sorry.
Yes, he's saying something.
Lordship, there was a direction on the earlier occasion, Lordship, there was a direction to furnish me a copy during the course of the day, Lordship. That has not been furnished to me. And Lordship, there was an inquiry by the court, Lordship, whether the representation, it's a contempt matter, Lordship, whether the representation was submitted before the Director of Health Services or not. Lordship, I have the instruction, Lordship. It was never submitted to us, Lordship.
We'll pass an order in his presence on the next one. Meanwhile, copy of the petition be furnished to Mr. D. Upamanu, Learned Standing Council, Health Department.
Obliged, Lordship.
Learned Council for the respondent. Yes.
Yeah, your lordship.
Yes.
Your lordship, I beg to mention the PC number 5981 of 2022 for listing. Your lordship may kindly fix it on any day which is convenient for you.
You go and approach the bench register. I have asked him to accept all urgent matters, right?
That's free, your
Yes,
lordship.
yes.
my lord.
Obliged, your lordship.
Item number 15, my lord. I am praying for taking the matter of 9th. my lord.
No,
15.
9th we are not free. It may be suitable for you, but what
10th.
matters is our convenience.
10th, my lord.
Sorry, if it is not taken today, then in the 3rd week of March.
Then the 13th.
Item number?
15.
Item 15, on the prayer of Mr. Kondakar, Learned Counsel for the petitioner, let this matter be listed again in the 3rd week of March 2023. Yes.
Please, Lordship. Lordship, prayer for listing a read appeal, Lordship.
Read appeal. Difficult prayer to consider.
Lordship,
Read appeals are taken by division bench.
Daily list for withdrawal, item 1.
Where is lordship?
Yes.
Lordship, the order is complied, lordship. And this is got appointment.
Mr. AMS Majumdar, Learned Counsel for the petitioner submits that the order of this court has been complied with and therefore this contempt case be closed. Taking note of the submission of Mr. So-and-so Majumdar, this contempt case stands closed.
Your Honor, I meant to mention part 2, item 2 and 30.
Mentioning is over. You talk to her now.
Item 3.
Lordship, item number 2 is there, Lordship, and he has
Yes.
Lordship, and item number 2, probably my learned friend has wrongly mentioned this item because he is not the counsel for the petitioner. He has wrongly
He
mentioned
wants
this
to
item.
mention part 2, item 2.
Part 2. Actually, he was mentioning about the part 2 item.
Item 2.
Yes.
Lordship, page 16, Lordship, I have clarified the presentation, Lordship, and I have the instructions.
So you have not served copy.
No, Lordship, I have not received. He said he has.
No, it has been served. But my learned friend is saying he has not received, but I have the information, it has been served.
Served upon whom?
Served upon the. I'm just getting that information with regard to that. It has been served.
Hmm.
And more to that, Lordship, on 8th February 2022, I received the communication from the petitioner. Pursuant to this representation submitted by the petitioner, they have initiated the process. And now there is a specific direction of the Honorable Court to reinstate the petitioner by correcting the date of birth. But
Lordship, may kindly see, look at page 16 and then my instruction, Lordship, and the last order as well, Lordship. That representation was never submitted to us.
Lordship, kindly
And my
take up the matter
instruction
after
is there,
some
Just a
time.
minute, just a
Yes.
minute, just a minute. So you furnish a fresh copy of the, submit a fresh copy of the representation.
Lordship, what I'm submitting,
Hmm.
pursuant to my representation, they have initiated the step.
Right, then we'll fix it for hearing because the contempt case is this.
Exactly,
we
Lordship.
can't-
Kindly fix it in the next thing, Lordship. Anyway,
Usual course hearing. Heard Mr. SP.
because there's some
Chaudhary.
urgency in the matter, Lordship.
What is the urgency? You
Because
are
the
not
person,
following the instruction of the court.
no, what I'm
You
submitting,
will have to submit a representation.
I have submitted, Lordship.
They are denying,
Exactly, that is what I'm submitting, Lordship.
all right.
Pursuant to the
Mr.
representation, they have
SP.
initiated the
Chaudhary,
step,
also
Lordship.
petitioner
Lordship,
also
kindly,
Mr. D. Upamanu, learned counsel appearing for the respondents who has obtained written instruction dated 2/3/23.
and this is not the correct
According to
instruction.
which the Directorate of Health Service has not received the representation stated to have been submitted by the petitioner in terms of the order dated 20/12/2021 passed by this court in WPC number 2307/2019. First up, Mr. Chaudhary has however refuted such submission and contends that not only has his client
On
submitted
8/2,
the representation on 8/2/2022,
yes.
but steps have also been initiated for redressal of his grievance pursuant to such representation. Full stop. Therefore, the submission of the learned counsel for the respondent is untrue on facts. Full stop. Such controversy cannot be resolved unless further clarificatory affidavit
I'll
is
submit my affidavit, Lordship.
filed on that behalf.
Yes.
In view of the above, this matter stands adjourned for 2 weeks so as to enable
Yes,
the
Lordship.
petitioner to file additional affidavit. A copy of the petition be furnished to
Yes,
Mr.
sir, I'll do that.
Upamanu during the course of the day.
Obliged, Lordship.
Retain a copy of the written instruction dated 2/3/23 in the record.
Item 3.
Lordship, may kindly turn to page 10.
Which order has been violated?
Order dated 03/11/2020, Lordship. Para 6.
Hmm. So no decision has been taken.
Yes,
Your
Lordship.
name, please?
But-
Your name, please?
Q-Kiba, Lordship.
I heard Ms. Q. Cuba learned counsel for the petitioner. Peruse the amendments made in the petition alleging willful disobedience of the directions contained in order dated 3/11/2022 passed by this court in WPC number 6817/2022. This contempt case has been filed. Full stop. Issue notice returnable in 6 weeks. Petitioner to take steps for service of notice upon the respondent by registered post to PD.
Obliged, Lordship.
Yes.
Order
Where is the order?
Order annexure 12, my lord. Page 64 to 67. Page 69, my lord. Earlier, petitioner approached you somehow because that filing a contempt petition. That was closed with a reaction of another 2 months.
Mr. P. Talukdar, learned counsel for the petitioner. Order dated 16/9/2022, passed in WPC 5290 of 2022. Bagi hini eke. At a respondents hobo. Yes.
Item 5.
Mayor, please, your lordship, order dated 1/12/22. Passed in WPC number 686. Page number 24, paragraph second, my lord.
What is your name?
H. Mehdi.
H. Mehdi, 1/12/2022 in WPC number 6386 of 2022. Sole respondent. Where is the order?
Wait, your lordship. Order.
Your name,
is on
please?
P. Borua.
P. Borua, order dated 28/1/2022, WPC 5330/2017. Yes. Multiple respondents.
Item 7.
May I please, lordship. Lordship, in this matter, lordship, the petitioner was serving the junior engineer, lordship, awarded penalty, lordship. The lordship, in terms of last order, lordship, the authority has been already passed in order, lordship. We have challenged this order, lordship. The order, lordship. Lordship, by submitting, lordship, liberty may be given, lordship.
So your proceeding has been dropped,
Yes, lordship.
so nothing survives. Is it not? The appellate authority, huh?
No, your lordship, basically, he has actually not made the chief secretary a party. Now, if your lordship peruses to page number 39 of the writ petition, he has filed the appeal before the chief secretary. Now, chief secretary is not a party. Now, and his prayer is basically a direction, a mandamus seeking the respond number 1, who is not a party to dispose of
No,
the.
what is this order? It says the disciplinary proceeding is dropped,
So it's
but penalty of withholding 2 increments for 2 years.
So he's challenging that penalty of withholding of 2 years increment.
But how can it be done? If you drop the disciplinary proceeding, then how can you impose penalty?
lordship, my liberty may be given, lordship.
Oh, you take your seat. You don't even know what is your case. Mr. Bora, there was a disciplinary proceeding initiated, charge proved, penalty awarded, appellate authority says disciplinary proceeding dropped, but the charge will remain, penalty will remain. What is the meaning of this? Tell him to come. Principal Secretary, Panchayat and Rural Development, tell him to come. You go through this order.
And
Have you seen it?
yes, yes,
And explain it to us. Otherwise, call him.
he'll be in a better position. He is
Yeah,
the-
call him.
Yeah, you have to receive it.
Call him, we'll call up after 5 minutes. Yes. Is there something we are missing or is this the way things are? That's all I want to find out. Proceeding dropped, penalty imposed. What is the meaning of this? Yes. We would like to hear it from the officer concerned. So you ask him when he can come.
May it please your lordship. My lord,
Yes.
I will travel your lordship to page 16,
Hmm.
1/6. Second paragraph, resolution number 4. Annexure B, page 16. My lord, to this meeting proposed such and such in the petitioner, member of landowner such and such, her name is proposed for training as a Jolomitra against the chiller, certain name and name is the second one. The Horokanto Halo is the second employee, and me, the petitioner, Latumoni Halo is the first one. My lord, and next, your lordship may turn to page 20. Page 20 is the terms and condition applicable to engagement of Jolomitras. And second paragraph, your lordship will find that page 20, they are entitled to get 6,500 for remuneration. Next, my lord.
So here issue notice has to go.
My lord, only thing, my lord, subject to only thing, my lord, pendency may not be a bar for if they are entitled, if I am entitled to give my remuneration. Page 29, serial number 77, my name is.
All right, heard Mr. P.K. Rachoglu, counsel for the petitioner, aggrieved by non-payment of honorarium for the period of 6 months as claimed by the petitioner. This writ petition has been filed seeking a writ of mandamus. I have perused the amendments made in the writ petition. Mr. R.R. Gogoi, learned standing counsel, PH Department, Assam, prays for 4 weeks time to obtain instruction in the matter. Prayer allowed NOM 4 weeks since Mr. Gogoi has appeared and accepted notice
Respond number 3, Your Lordship.
on behalf of respond number.
3.
Why not 1?
Oh, yes, Your Lordship. 1 and 3, sorry.
Oh, 1 and 3. No formal notice is required to be sent to the said respondent. Respondent's extra copy of the writ petition be furnished to Mr. Gogoi within 3 days from today. Petitioner to take steps for service of notice upon the remaining respondents. It is made clear that pendency of this writ petition shall not constitute a bar for the authority to redress the grievance of the petitioner in accordance with law. If so advised.
Acknowledged.
May please, Your Lordship, regarding compassionate appointment, Lordship.
Father died. Which year?
2003, Lordship.
2003.
2003, my lord.
Oh,
Immediately, mother applied for my compassionate appointment. And he has filed representation on several occasions, and her name was also.
Why suddenly in 2023?
My lord,
After
Lordship
20
may
years.
Lordship may come to the last annexure, this is annexure 10, my lord, page 20, my lord.
No, I want to know why did it come to the mind of the petitioner after 20 years that she should meet a lawyer and file a writ petition for compassionate appointment? Did you not ask her this question? Huh?
No.
No, but this is a very relevant question. Suddenly after 20 years,
My lord, the
she
time to
is
time, my lord, she is
looking for
filing-
compassion.
Time to time, she is filing representation.
That's right. So
And,
instead of filing
her
it
case
again and
was-
again,
her
why?
case- Her case was not considered, and in the meantime, when her son also become eligible, and he has done his graduation, and then she has made
So
application
is it a
for.
family
consider-
business to get compassionate appointment? Okay, if I didn't get, let my son now start. And it is
And they
the.
have,
Hmm?
by annexure to the 10, they have forwarded his name
Hmm.
for consideration in the year 2019. My lord.
All right, now if you ask him, he'll say, give me time to obtain instruction. That is how these absolute lifeless petitions are piling up in this court. You will say you want time to obtain
Lordship,
instruction?
Exactly, Lordship.
What is the instruction you want? After 20 years,
Lordship.
somebody is coming for
Exactly,
compassionate
Lordship. I
appointment.
have the submission in delay also, Lordship.
What is the law on that?
Lordship, that I am not prepared for that, Lordship.
I'll record it, that the government, state council is not prepared to even
It's
respond to
central,
this.
Lordship.
Why you are not prepared?
Lordship, I prepared.
You didn't get
facts,
the
Lordship.
copy yesterday?
Lordship, I got.
Then why could you not prepare?
Lordship, I reviewed the facts, your Lordship.
Huh?
I am reviewed the facts, your Lordship.
What is the law?
Lordship, law is regarding that the eligibility is there, Lordship, for the group C post, Lordship. But there is some delay in lectures also in the
So I'm asking you, where is that law? Show me. I'll close it
There are
today. sir.
notifications, Lordship.
So the government is piling up the cases, actually. I'm sorry to say. You all can't come, these are settled matters,
is a-
thousands of cases are coming every day.
In my
Every
humble-
case you want time to obtain instruction?
In my humble submission, Lordship, this, the annexure that my learned friend is relying on, that is also 2019, Lordship.
Hmm.
And that is not for consideration, Lordship, that was just.
I am
forwarded.
asking one simple question. At least half a dozen compassionate appointment cases come to the court
Lordship,
every day.
I agree, Lordship.
Majority of them are filed after 15 years, 20 years, 19 years. And the government advocate says, I want time to obtain instruction. Why are you not ready with the decisions to show that this is not maintainable? What is the reason? You understand the consequence of that? We issue notice.
Filing of lots of cases.
Yes,
Lordship,
and then it affects the genuine cases which require, of
Exactly.
course, genuine or not is another matter. But then why should we issue notice in a matter which is apparently barred by time? Only because the government is not doing its job. The government council, not the government. Heard Mr. U.G. Sekta, learned counsel for the petitioner. The prayer in this read petition is for issuance of a direction for appointment of the petitioner on compassionate ground. It appears that the father of the petitioner had expired in the year 2003, and therefore this read petition has been apparently instituted after a delay of 20 years. Full stop. In view of the above, the read petitioner appears to be prima facie barred by time. However, Mr. D.J. Das, learned government advocate, Assam,
Lordship, it's central, Lordship.
learned CGC, appearing for the respondents,
Lordship, all
is
the rest
not
of the
ready
ones-
to respond to the said query and prays for time to obtain instruction. In view of the above, issue notice of motion returnable in 8 weeks. Since Mr. Das has appeared and accepted notice on behalf of all the respondents, informal notice, extra copies of the read petition be furnished, etc.
Bless, Lordship.
Question of maintainability of the read petition is kept open and shall be gone into at this stage of admission hearing. Don't promote these litigations. This is not a good idea. You're giving false hope to these people and
Wait, please, your lordship. Well, matter partitional, matter partitional, compassionate appointment, my lord. Then, well, petitioner's father died, well, at 1/24/3/2015, well, in service, my lord. Thereafter, well, the DLC had recommended the case of the petitioner, my lord. Now, well, the state level committee had rejected.
notice, you don't have instruction of yes.
No, Lord.
Notice, Mr. So-and-so for the petition. The matter pertains to prayer for appointment on compassionate ground. Peruse the amendments made in the read petition, NOM 8 weeks. Since Mr. H. Chakravarti, Mr. S. Bora, learned, you're appearing as? Technically right, Mr. H. Chakravarti, learned government advocate for 1
and 3.
and 3. And Mr. Bora, S. Bora, learned counsel for respond number 2. Service of notice on respond numbers 1, 2, and 3 is deemed to be completed in this case. Extra copy of the read petition be furnished to the learned department counsel, requisite in numbers, so as to enable them to obtain instruction. Stop petitioner to take steps for service of notice upon the respond number 4 by registered post within a week from today. Yes.
Obliged, obliged.
Item 11.
Right, please, your lordship. This matter is relating to compassionate appointment, lordship. Lordship, petitioner's father was died in the year 2007, lordship. Thereafter, immediately he applied. And on 24/5/2007, lordship, initially. DLC
Yeah, also
placed-
you don't have the instruction, obviously.
Lordship,
Since the DLC
Recommended.
what happened with the SNC, that instruction is required.
No, but 2007 father died. 2023 is a read petition maintainable.
No. The
So
DLC
22
then
recommended.
recommended your lordship in 2022.
DLC,
Recommended your lordship in 2022.
then after that, what happened?
That is the question. He's saying that SNC, what is going on with the SNC? He's not aware. SNC is not taking action. So that is where the
17/9/22, lordship. Again,
How can the DLC recommend in
matter
2000?
recommended.
that is there. Your lordship.
What is happening with your department?
Because, lordship, in the year 2007, lordship, my
See,
matter was.
a compassionate appointment is not a matter of right.
Yes, lordship.
It is a soothing balm which has to be applied immediately.
Yes.
Otherwise, it is over.
Lordship.
This is not that something happened 20 years back. Now I have become a major. Now you give me.
Yes, lordship.
My post was reserved. It's not like that. So I will list all these cases and dismiss only because they are not ready. Mr. So-and-so for petitioner, so-and-so. You have four
Respond number 1, your lordship.
and Mr. Sharma, learned standing council held for 2 and 3. On the request of the learned council for the respondents, this matter is directed to be listed again after 2 weeks for motion so as to enable them to obtain instruction and appraise this court as to whether any action has been taken by the SLC on the recommendation of the DLC, and if so, what is the outcome? 2 extra copies of the writ petition be furnished to the learned.
Item 12.
May it please your lordship. The petitioner is before your lordship against the removal order, removing from service by the respondent authority and I lordship. At this stage, notice may be issued, lordship.
Sorry, what is your,
Lordship, the petitioner is before your lordship against the order of removal passed by the respondent authority and I lordship, removing the petitioner from his service, lordship.
all right.
Lordship, at this stage, notice may be issued, lordship.
What is the date of the order?
Lordship, volume 3, page 589, lordship, date of the order 8 October 2021, your lordship.
So there is some delay, you have preferred an appeal.
Lordship, I have preferred an appeal. Thereafter, I have also preferred a review, lordship. Thereafter, I have before this on I report.
All right, heard Mr. P. Borderline and counsel for the petitioner being internally agreed by the order dated 8/10/2021 imposing the penalty of removal from service.
Lordship.
The petitioner has approached this court by filing the instant writ petition. Mr. Borderline submits that the impugned order has been issued in violation of the principles of natural justice
Lordship.
and the procedural safeguards
Lordship.
available to his client under the law. Mr. N. Dekal and his standing counsel, Numaligarh Refinery. You are standing counsel?
Not a standing counsel, madam, but counsel.
But you are always standing for Numaligarh and you are not a standing counsel. Very difficult.
For 2 and 3, madam.
Mr. N. Dekal, the non-standing counsel. Mr. N. Dekal and counsel has appeared and accepted notice. See, the problem is, if you are not a standing counsel, then how can you appear today?
They served, my lord, I have accepted it, they are,
No, why have you accepted?
because I have instructions to appear, my lord.
That means you are a standing counsel.
But there is no official communication, my lord.
You must ask them why it is not there.
My lord.
No, there's nothing funny about it. The point is, unless notice is issued, a respondent cannot just appear except for a caveat.
My lord.
But in case of a standing counsel and notified counsel, the matter is different. There the respondent gets a right to be heard.
I'm with your lordship, my lord.
Yes. So should we ask them to do something about it, or you'll you tell them the
I'll tell
court
them.
has asked, why haven't you notified it?
My lord.
Mr. N. Dekal and counsel has appeared and accepted notice to respond numbers 2 and
2 and
3.
3.
Whereas anybody for
My
one,
learned friend is appearing for 1, my lord.
whereas Miss,
Respondent number 1, Union of India,
yes, your name
Name.
please,
Union of M. Konyak.
M. Konyak. Whereas Miss M. Konyak and the counsel has appeared. You are a CGC.
PGC, yes.
You are appointed as CGC.
Yes, my lord. I'm
Your
for
seniors have
PGC.
gone somewhere, so you've been asked to appear.
Yes, my
All
lord.
right. Then a CGC has appeared and accepted notice to respond number 1. Only 3 respondents, right?
4, 5 and 6 years made some officers party by name, my lord. Notice will have to go.
Service of notice upon the respondent numbers 1 to 3 is deemed to be complete in this case. Extra copies of the writ petition, requisited numbers be furnished to the learned departmental counsel. Petitioner to take steps for service of notice upon the remaining respondents by registered post with AD.
Lordship, may I submit, lordship? Order of removal and subsequent order passed there to lordship.
Yes,
Lordship
that's
has
why
said inter alia.
inter alia.
Lordship.
You know the meaning of inter alia? That is the
Obliged.
meaning, yes.
Item 13.
May it please your lordship. Actually, this is a case of denial of opportunity to the petitioner to put forth their candidature for the post of Gao Pradhan. So,
Now, Pradhan appeal.
no, lordship, actually, let me just put forth my case. Page number 15 is the advertisement. And what happened in the advertisement is that the name of our village, although the lot number is mentioned, the name of our village is not there. And that also maybe I'm leaving to them. It may be inadvertent also because of the fact that the name of our village is Alisinga Uriamguri. But here 2 other separate villages having similar names. One is Uriamguri and one is Alisinga. So these 2 were mentioned. And when we went to put forth our candidature, we were told that because the name of our village is not there, therefore we cannot apply for the post. So lordship, only thing is that if some amendment in the advertisement is made, because ultimately the lot is same, they are going to appoint Gaubura for our village. The petitioner as well as youths like him.
Why don't you obtain instruction? We'll place it on 10th.
Otherwise, he is not eligible.
Huh?
Otherwise, he is not eligible.
Is-
Lordship,
is-
as-
is-
yes, yes.
Advertisement
was already
published,
Maybe whatever you have written.
Oh, yes. No, anyway, no, we have given our Aadhaar card and all, it is 36 actually, from the Aadhaar card. Actually, no type.
Achha, anyway, you find out what
Lovely,
will happen. We'll post it for motion on 10th.
Lordship.
Okay.
Right. Heard Mr.
MK Chaudhary.
M.K. Chaudhary, learned counsel for the petitioner, peruse the amendments made in the writ petition. The petitioner has alleged that due to an anomaly in the advertisement
Yeah.
notice issued for appointment of Gapradhan, his client could not, he could not appear. First up, on the request of Mr. S. Datta, learned standing counsel, Revenue Department, Assam, and Mr. H. Chakravarti, learned government advocate, Assam. This matter is directed to be posted for motion again on 10/3/2023, so as to enable them to obtain instruction responding to the allegations made in the writ petition, facilitating disposal of the same at the stage of motion hearing. 2 extra copies of the writ petition be furnished.
May it please the lordship, and the matter pertains to regularization of the service of the petitioner who has been working as a work charge power pump operator in the irrigation system, my lord, in Karbi Anglong. My lord, a representation was submitted in the year 2006, which was forwarded from the Karbi Anglong Autonomous District Council to the Office of the Chief Engineer twice, my lord. Still, my lord, no action has been taken till now.
I may need instruction. I may be under time for instruction.
Letter of obtain instruction.
Yes, my lord.
Right, heard Ms. R. Burwal and counsel for the writ petitioner. The petitioner herein claims to have been appointed on fixed pay basis in the year 1986 as a helper to the power pump operator in Borjan lift irrigation scheme. First up, after rendering long years of service, the petitioner had submitted a representation dated, what is the date of the representation?
My lord, the representation was accepted on, my lord,
Representation
4th of September 2006, my lord.
for regularization of his services, which was accepted by the authorities on
On 4th of September 2006, my lord.
4/9/2006.
Chief
However,
engineer.
And since then, no concrete action has been taken in the matter, as a result of which the petitioner has been compelled to approach this court by filing the writ petition. Full stop. Ms. D. Nyog,
DS Nyog, your
DS
lordship.
Nyog.
That's number 1, 2, and 5.
Learned Standing Council Irrigation Department, Assam, as well as Ms. S. Kemprai, Learned Standing Council KAC, have prayed for some time to obtain instruction in the matter. NOM 6 weeks, since Ms. Nyog has accepted notice for respond numbers
1, 2, and 5.
1, 2, and 5, and Ms. Kemprai for respond numbers 3, 4, and 6. Service of notice is deemed to be complete in this case, extra copies of the writ petition, etc., etc.
Lord, she made
It
please to indicate, my lord, that he was appointed as a work charge power pump employee in 1994, my lord. Initially, he was appointed as a fixed pay employer. Later, he was appointed as a work charge operator, my lord. in
Initially, it
1994.
was related to terms of Kobo. Thereafter, he was appointed as a work charge employee.
Power pump operator on 28th of July 1994, my lord.
Work charge power pump operator on
On 20th of July 1994, my lord.
27/1994. But he
Diploma.
Yes.
Item 16.
May it please your lordship. My lord, a coordinate bench of this honorable court has decided, my lord, the issue, my lord, involved in the present writ petition. And in that view of the matter, my lord, it's a covered case. My lord, what has happened? My lord, there is a scheme for completion and appointment issued by the government office memorandum in 2015. And there is one clause, my lord, saying that at the time of the death, my lord, of the government employee, if my lord, he does not have minimum balance of 3 years,
That has been struck down.
that has been struck down. And your lordship will find the operative part at page 64, my lord. Para 19.
But your client's case was considered. and
Yes,
released
that
before
is, I'm pointing out to your lordships, my lord. If your lordships is, my lord, page 37, annexure 5.
So now you want your case to be reconsidered.
Exactly, well,
It
same
will
order.
be because see, they did not urge before the court. Maybe they are not even aware that this order will not be used to reopen disposed of cases. Even today, he is not urging it. So we'll record that the government does not have any objection.
No,
That's
your
all.
lordship, I
No,
have,
but you are not urging it.
no, your lordship, the thing is, I've just been instructed telephonically that the department is actually contemplating filing an appeal. I don't have any written instructions to that effect, so may I pray that matter be listed after 4 weeks, because by that time we'll file an appeal before the honorable division when challenging this judgment.
No, other things apart, I'm also of the prima facie view that this cannot reopen cases which are already
Yes,
rejected.
that is also there.
These things too, but they have not, surprisingly, last 2 or 3 occasions, the government advocate is not even whispering. So what to do?
My lord, only one aspect of the matter. If your lordship comes to page 37, 3 candidates, my lord, their cases have been rejected. My lord, petitioner was one of those 3. And my lord, the other 2, my lord, Vikas Talukdar and Gautam Das, their cases have been allowed.
No, Mr. Talukdar,
My-
please understand one thing. We are on law.
Exactly, I understand. My
See,
lord.
the point is, the read court will see if the decision is arbitrary and illegal,
Yes.
right? So on the day on which the decision was taken, the factors considered by the DLC or SLC, were those germane or were those irrelevant? Now, they say that because of this reason, this clause, meaning thereby that the deceased did not have more than 3 years left in service, we cannot consider your application because of notification number so and so, so and so. That is disposed of. Subsequently, somebody challenges it and the learned single judge says this is unconstitutional. That view is open to challenge. And if the state files an appeal, that will be considered. But the point is now, can you say that now then go back to all those cases which were closed earlier and now reopen it? How is it feasible? How is it feasible? You tell
Not all
me.
the cases, my lord.
What happens to vacancy is gone
Not
already?
all the cases. The cases,
Not all. Even one case, is it permissible?
yes.
Is it permissible under the law? That's what I'm saying.
My lord, I am asking, my lord, on the ground of, my lord, parity. Because your lordship will see, by the same, my lord, order.
Today, I don't have time.
Right.
Otherwise, I would have written a judgment answering your claim. There is no parity in these matters. Nothing. Heard Mr. S.K. Talukdar, learned counsel for the petitioner. Peruse the amendments made in the petition. The petitioner is practically seeking reconsideration of his case for appointment on compassionate grounds in view of the law laid down by the learned single judge in the case of
My lord,
Haskar Kuwar.
Huh?
Haskar Kuwar.
WPC 1646/21, my lord, and other connected cases. Page 41, start from there.
WPC 4617/2020.
No, my lord, 1646/21. Page 41, your lordship will find it.
1646.
All right. One six four six of the 2021 bracket Bhaskar Kaur versus State of Assam and others bracket close. This is the third bracket, and the bunch of connected read petitions. Full stop. Mr. Bora submits that the order passed by the learned single judge has not yet attained finality, and therefore he be granted some time to seek instruction. Prayer allowed. Issue notice of motion returnable in 6 weeks. Since Mr. D. Bora, learned government advocate Assam, has appeared and accepted notice.
1, 3, 4, and 5.
1, 3, 4, and 5. 4. And Mr. R.R. Gogoi,
Number 2, your lordship.
learned standing counsel PhD for respond number
2.
2. Service of notice is going to be complete in this case. Extra copies of the writ petition be furnished to the learned departmental counsel. So as to enable them to obtain instruction. You see, Mr. Talukdar, your client did not challenge that notification,
Yes.
right? He was waiting, he was fence-sitting, or rather he accepted the verdict or decision of the SLC or DLC that he is not entitled to be considered because of this OM. Now, because of some contingency arising, where the court says these judgments are prospective, unless specifically made retrospective. Therefore, going by your stand in this petition, per se, it is very easy for me to dictate a judgment. But I want you to examine these issues a little deeper and show me what is the constitutional right your client has. If you can do that, but it can't be that, all right, my case was rejected. Now the single judge has said that notification is illegal. So let them open everything. That is not permissible.
Correct.
That is not a tenable stand.
Correct.
In that context, I said I can dictate the judgment just now, unless you develop your case further. And if they prefer an appeal and it gets set aside, then that will save you the trouble.
Correct.
Highly
Obliged.
Same thing will be there.
Same thing, same issue.
Same.
Same thing,
Mr.
madam. I was
A.
rejected by
Kanikar.
SSR 10/2/2022, madam.
All right, same thing, list along with other.
Lordship, I appear for 1, 2, 4, and 5. GAD, the name has not been shown, but
Mr. C.S. America for 1, 2,
4 and 5.
and
Someone, I'll call someone, Mr. Pukan is there, 9.
who is for 3?
GAD, your lordship, there is actually.
Mr. A. Fukan, Learned Standing Council, JD for 3.
Madam, 19 is also.
19 also same,
Madam, same.
18 and 19.
18, I am appearing lordship, SLC rejected, recently rejected.
All of you want retrospective effect of the judgments. How is it permissible? You apply your mind before filing a writ petition.
Yes,
Who is in 18?
I am 18 lordship.
Achha, F.U. we are in 18, and who is in 19?
19 I am appeal.
And which other matter?
Lordship,
So this is item number?
18 lordship,
This is 17, madam.
17.
One by one.
Among the 17, no?
17.
17.
Mr. Kanikar in 17, where C.S. Hazarika, government advocate for 1, 2, 4, and 5, and Mr. A. Fukan, and SCGAD for respond number 3, right? Then item 18, who is appearing?
Lordship, I am
F.U.
appearing.
Borbia. And who are the respondents, council?
For the corporation department.
Give me the respondent.
1, 2, and 3, man.
Mr.
RB Goswami for MD Bora. My seniors name will be recorded, my lord.
Item 18.
And MD Bora for
Who is your senior here?
MD Bora, my lord. 1, 2, and 3.
MD Bora, learned council has appeared for respond numbers
1, 2, and 3.
1, 2, and 3, and Mr.
And 6, my lord. And 6.
1, 2,
3 and 6.
and 6, and who is for 4 and 5?
I appear for 4 and 5.
And Mr. D. Bora, learned government advocate Assam for 4 and 5. Service complete, right? And what about the other matter?
19
19, madam.
19. 19 again, A. Kanikar for petitioner.
1, 2, 4, and 5.
Is A. Talukdar, learned government advocate Assam for 1, 2, 4, and 5, and
GAD for 3.
A. Fukan, GAD for 3. These matters to be bunched together and listed for dismissal. Oh, what? No. We can have a category, na? Cases to be listed for dismissal. All right, you come up, make out a case, we'll hear you. Okay.
Develop.
Your pleasure.
Binding letter, item 7.
I have spoken to the secretary, and she said that the expression drop over here does not signify withdrawal. It means concluded.
Drop means concluded. New terminologies. Mr. Chaudhary, the appellate authority says the disciplinary proceeding is dropped. Penalty is confirmed. How is the court supposed to respond to this? And the order is passed by a principal secretary to the government of Assam.
Mention the explicit word, my lord.
The new terminologies, new expressions coming up.
In the meantime, I will instruct.
Huh?
We'll
Drop means drop. You better modify it. We'll have it on 15th March for motion. So and so for petitioner, Mr. N.K. Debnath, learned standing council, Assam, is for posting this matter again on 15th of March 2023 for motion, so as to enable him to obtain clarificatory instruction on the expressions used in the notification dated 23/2/23. More particularly, the one in the penultimate paragraph, where it has been reflected that the departmental proceeding has been within courts dropped. Now, wherein it has been mentioned that within courts, likho, the governor of Assam is pleased to drop the departmental proceeding, unquote, drawn against the petitioner, but the award of penalty of withholding 2 increments for 2 years with permanent effect appears to have been continued. Full stop. 2 extra copies of the writ petition be furnished to Mr. Devnath. Let them obtain instruction. You please tell your officers that once it is dropped, they can't say it is not dropped. Because we cannot presume that the government officers or the honorable governor doesn't know how to write an order. We can't presume that.
That's true.
We have to presume that the order is correct. The only option for you to say is that we didn't know how to write out the order. Either you say that
I'll convey them.
or you have to give him, you made a mistake. Nothing can be done. You can't drop a proceeding and then say that, sorry, we did not drop it. This is not child's play. It's a serious matter. You please talk to them. It could be a mistake, could be a slip of pen, but then it has given a right to him.
Right.
And the courts will have to go by what is the language, plain language. What option do we have? We always presume that the orders passed by the government, more particularly in the name of honorable governor, are on correct understanding and premises. We cannot presume that it is wrong. We may only see whether it is in accordance with law or not. And if we go to that aspect, it is not. That's the point here. Yes.
Supplementary list promotion item 30.
May I please get out? Someone out here. A SOCOS notice was issued trailing charges against the petitioner. Your lordship may come into the another page 48.
So give him the statement of allegation. That
Not
was
only
what we-
that, but subsequently development has gone, madam.
Huh.
Subsequently, Herman, by this rule 9 and 311, the charge has been framed. Subsequently, a letter has been issued from the additional register, that is 49.
Hmm.
Page 49, your lordship will find, along with the complaint. Identical. Actually, I have misfiled this one, my lord. Along with the complaint, you file same charges. The hearing has been fixed on 3-2. That's why we have filed this petition.
3-2.
Yes, madam. That is the notice in the notice 3/2/2023. Hearing has been fixed on this allegation. Now, your lordship in the complaint, your lordship fine. Same charges.
3-2 is gone already.
No, my lord, no. There is same.
3-2 is already gone,
No, that-
lordship.
No, 3-2 has gone.
Hmm.
Subsequently, I have submitted representation that the application that it is already charges has been framed by the registrar. How can this is maintainable? I have said this one. Then another SOCOS has been issued, my lord. This is the case, my lord.
Okay, what has happened? SOCOS notice which is there, it was issued on 3rd of January, 2023, your lordship. And he has admitted he has received it on 18th of January and
Yes, yes.
giving 7 days time, 24th January. Thereafter on 23rd, just one day before 24th, he submits a representation stating he is trying to collect the records. He requires another 15 days. So 15 days is over on 8th of February. On 9th February, the RCS again writes to him stating giving another 7 days time to submit his written submission. His case, your lordship, is that the criminal proceedings are going on, your lordship. So the disciplinary proceedings should be stayed. Now, the legal position is clear in that case, your lordship, that the disciplinary proceedings.
Paul Anthony is.
No, I am not on
Yes,
that. I am
your
not.
lordship. That is there.
I am not on that.
And your lordship, the other letter which he is mentioning, your lordship, that is the inquiry done by the edition and he has.
How, my lord? How it
That
is?
that is in regard to the inquiry, in regard to the hearing. But subsequently, the letter of the RCS is there giving him another 1 week's time. So twice he has been granted time, your lordship.
Not that. In this here, the additional
And
register has fixed for
Lordship will
employee.
come to his letter, your
So,
lordship.
Srinath, why don't you let him finish?
Yes, my lord. definitely.
This court has never
Yes, my lord.
refused
Sorry.
to
my
hear
lord.
anyone.
I'm sorry, ma'am.
Hmm.
Complain, your lordship, kindly to go.
Lordship come to his
The
letter.
most important reason for the hearing is for the court to understand it,
Yes, my lord. Yes.
not for you to go and saying whatever you
Yes,
feel
my
like.
lord. Yes. Sorry, ma'am. Sorry.
So as long as the court doesn't understand, no order. And you are interfering at the moment. Take
Sorry,
your
ma'am.
seat.
Sorry, I'm sorry. They are extended.
Yes.
Yes, your lordship, you come to page 51, his letter, your lordship, which he had mentioned. At para 3, the undersigned is innocent, but the undersigned is not in a position to file a written
So
statement.
there are two show cause notices.
Yes, your lordship.
First one was issued on 3/1/23,
That is right, your lordship.
right?
That is, your
So
lordship, that is right.
he is asking for quashing that.
Yes, he's
And
asking,
then again on 9/2/2023, another show cause notice has been
yes,
issued.
he sought 15 days time, your lordship.
Hmm,
He, first show cause was on 3rd of January, your lordship.
hmm.
Then he writes a letter on 23rd of January, saying that he needs 15 days time to organize the record.
All right, so that means another show cause will be issued.
So then on 9, 8, 15 days is over.
Hmm.
On 9, the RCS again writes, your lordship, that you are granted another 7 days time to submit your written submission.
Hmm.
So opportunity is granted to him.
Where is that 9/2/2000?
Ninth letter is, your lordship. That is at page 50, your lordship. Page 50, 9 February 23. Lordship will kindly see second last para, your lordship. Your written reply against the charges level upon you should reach the undersigned within 7 days from this communication.
Hmm.
So
So
again,
after
opportunity.
this, what has happened?
After this, your lordship, he has come here now, your lordship. He wants that the
No.
disciplinary proceedings should be stayed because, your lordship, there are criminal proceedings.
The
And he has,
disciplinary proceeding has not been initiated.
yes, your
No,
lordship.
I am not on that, I am not on that, my lord.
What are you on then?
No, no,
Everything
now-
I ask.
Now is there,
Hmm,
my lord, if it's, then on 3/1, focus has been issued,
hmm,
framing some charges, my lord.
hmm,
Then on 25/1/23, I have take time to submit the WS.
hmm.
Then on 23/1/2023, additional registrar again asking me to be present for hearing
Hmm.
for an inquiry on 3/2/23
Hmm.
in connection with the whatever charges already framed.
No, where is the framing of
Yes, my
charge?
lord, yes, my lord.
Where is the charge?
Yeah, that is the another 3, sorry, that suppose notice that another 814.
No, show cause notice is not charge framing.
Manava.
No, don't.
No, no, okay, my lord, that. Then this Socos notice, Socos notice under Article Rule 9 and 311 has been issued.
Hmm,
This one, my lord.
hmm.
Though alleging that so and so, some
Mr.
allegation.
Sinha,
Yes.
please answer a simple question. Has charge been framed against your client?
My lord, by,
Yes or no?
no, by
No.
issuing this.
Then
some
we are not
allegation-
entertaining this.
My
You are
lord,
wasting
that's
time.
what, that's 1 minute, my lord.
Hmm.
Then how
You,
superseding
you
the-
have started this matter on a completely wrong argument. You are saying charge has been framed. There is no charge framed.
Well,
The
some
department
allegation-
is not entitled to
My
issue a
lord,
show cause
my lord, the inquiry which the registrar is going to be held, my
notice. Hmm.
held. Again, additional registrar has issued notice.
How, who told you? The
Yes,
Register has called you up.
This is 25
No,
1.
who has told you that inquiry will be held?
That is on 25/1/2023.
Who has told you that inquiry
the-
will be held?
Additional registrar of property society.
Where is that letter?
Yeah, that is page 49.
Yes,
Page 49.
yes.
Page 49. With reference to the subject cited, that the undersigned is inquired into the matter of allegation of corruption by you as Dadian Secretary of Bikrampur, so and so accordingly.
So this 25/1/2023, is it preceded by a charge sheet being filed?
My lord, the complaint is the allegation, same allegation. Complaint I have
It
just.
seems there
This-
is no understanding of
This
law,
is-
both
yes.
sides.
And no,
The inquiry,
Unnecessarily wasting court's time. I heard Mr. B. Sinha, counsel for the petitioner, also heard Mr.
V.
Yeah,
Rajkar for the
Huh?
Corporation Department. Your
Mr.
V. Rajkar.
V. Rajkowal, understanding counsel corporation department, Assam. In view of the amendments made in the petition, the learned departmental counsel to obtain instruction and appraise this court as to whether any charge sheet has, any memorandum of charge has been served upon the petitioner prior to issuance of the letter dated 25/1/2023, directing him to appear for an inquiry, full stop. List this case again on 15/3/2023 for motion. Two extra copies are repeating.
my lord, till that no coercive action.
Nothing,
No
nothing.
coercive action.
What coercive action?
Now, I may place suspension, my lord, because now second shock of this notice, that one, my
Yeah.
lord.
That's not the law. Suspension they can. There is no problem with suspension.
Obliged.
Supplementary
But as far as I'm concerned, lordships wanted one or two judgments on disproportionate punishment, my lord. And as far as government was concerned, lordship directed them regarding two aspects. The matter would be regarding on disproportionate punishment, and following upon, they should also consider for voluntary retirement.
Where is the, Mr. Bora was appearing, it seems,
Can I come after some time? Let him come, my lord.
or should we fix it on Thursday? So Chaudhary,
Not
I-
Thursday, let it be on Friday, my lord.
yes, Friday. I'm traveling today,
No, no,
therefore, don't want to.
Lordship,
Yeah, no, no.
Bora is on.
Or why not on Monday then?
Okay. Okay.
Heard Mr. K. N. Chaudhary and senior counsel listed by Mr. R. M.
Well,
Dikal
I have a
and
matter,
Company
actually.
Petitioner, yes. Some accommodation has been sought in the matter on behalf of the Learned Standing Council Health Department, Assam. He's not well.
No, he is coming, Lordship. He's on the way, Lordship.
In view of the above, let this matter be listed again on 13/3/2023 as a fixed part-heard matter.
Lordship.
Item 20.
None appears for the petitioner on call. Mr. N. K. Devnath, Learned Standing Council, PNRD Assam, as well as Mr. D. Bora, Learned Government Advocate Assam are present. Since the petitioner's counsel is absent today, this matter stands adjourned for 4 weeks. Yes, go ahead.
Item 21.
May I please, your lordship?
Yes.
Lordship, in this case, the present petitioners were initially working as a contextual basis. And in the year up to 1994, in the year 2000, my lord, their posts were regularized. And without giving any opportunity, their appointment were cancelled, my lord. Hence, they were approved before the Honorable High Court, filing a writ petition by WPC number 7146/2000 in the year 2000, my lord. And 2003 order was passed to consider their appointment, and if they any candidates are overage, it was also directed to consider. But without giving them any opportunity, advertisement was published, my lord. And without considering recruitment process was initiated, and they again approved before the Honorable High Court by filing another writ petition, my lord. Kindly may perused at page 67, and that petition, writ petition also directed to consider their case, my lord. Page 67, my lord. And operative part is 73, my lord, of the order. 73. The bottom paragraph, the above next middle portion, my lord. May I read, my lord?
1 minute, 1 minute.
My
Yes. So this order was passed in 2006.
Six, my lord, with my respectful subsequent is that, my lord,
Wait a minute.
my lord,
Same petitioners in that proceeding also.
my lord, my lord.
What happened after 2006?
They have not been appointed till date, my lord,
So then you come to court in 2021
my lord.
after a lapse of about.
Another
13
read
years.
appeal was also filed, my lord. In
Who filed
appeal,
writ appeal? Who?
The present petitioners also party.
Re-
Subsequently,
Writ appeal filed by whom?
the present petitioners, my lord, they were the party.
Against which order?
Against the order, my lord. Read appeal 357/2009, another read petition subsequently.
On the prayer of learned counsel for the parties, this matter stands adjourned for 4 weeks. I am asking you against which order you are giving me the number of writ appeal.
My
There's no
lord,
time for all these things. Yes, next matter, please. Come prepared. Come prepared.
I believe a fixed date, my lord.
Yes, in the month of May. Fixed item in the month of May, first week of May.
They paid your lordship. Your lordship kindly see the last three orders.
Hmm.
Small order, madam. Last order, they.
Yes, what do you want to show?
Lordship,
What do you want to show from the 3 orders?
lordship, and earlier your lordship order,
See,
Yeah.
this matter has been listed for admission.
lordship,
You have to first say, are you seeking a disposal on admission or what is the order you are seeking?
lordship, they not yet file affidavit, madam.
Sorry,
They not yet file affidavit.
say that
My-
they have not filed affidavit.
Lord,
You want to file affidavit?
yes, madam, I'm appearing on behalf of Mr. P Naik, my lord.
Huh? Sorry?
I'm appearing on behalf of Mr. P Naik, standing counsel PWD, my lord.
Hmm.
My lord, we have sent the affidavit for vetting, my lord. I pray for 1 week's time to file the affidavit. That may be fixed, my lord.
Yes.
Last 2 days.
Ms. P. Bora, learned counsel for the petitioners. Present. Ms. P. Borua, R. Borua, learned counsel appearing for the official respondents. So, numbers,
My lord, numbers.
see, these are things you have to be prepared. You should know which respondent you are.
1, 2, and 3, my lord.
1, 2, and 3 submit that the affidavit on behalf of the department is ready and shall be brought on record within a week. Full stop. In view of the above, register to list this matter again after 2 weeks as a fixed item by tagging the affidavit to be filed by the department with the record of this case.
That may be fixed.
Item 23.
Obvious.
Yes.
The matter is for parity of P and the respondents have filed affidavit. I pray for disposal at the administrative stage.
May I please, your lordship, lordship by senior is currently out of station, so may kindly adjourn the matter.
Some other dates.
30th of March. Mr. M.K. Chaudhary and his senior counsel is present on behalf of the petitioner. The learned CGC has prayed for adjournment on the ground that the arguing counsel is not available today. First, it is submitted at the bar that this matter is ready as regards pleadings and can be taken up for disposal at the stage of admission hearing. In view of the above and on the request of the learned senior counsel for the petitioner, register to list this case again on 303/2023.
All right.
Obliged, my lord.
Item 24 and 25.
That's legal.
Yes.
Well, in this matter also, the respondent is supposed to file affidavit.
Allow me 2 weeks time to file my affidavit, my lord. 2 weeks time to file my affidavit. I have received my
I don't have any objection, Lordship, I have another small prayer, my lord. My lord, by the order dated 3/3/2022, this honorable court directed the petitioners to participate in the selection process they are going to held. Now, my lord, day after tomorrow, the selections are going to be held. And out of the 6 petitioners, only 2 have been issued the admit card, 4 have not been. So there is a clear order from this honorable court. So all petitioners may be allowed to participate in the selection.
No, if there is an order, there is an order.
There is a 33, my lord.
What will say?
Why have you not said the problem will be that
No,
we'll set aside the entire selection process. You can't do something in violation of court order.
What is that? In petition number
Where
2307.
is the order? Where is the order?
My lord, 33/2022, the first matter.
33/2022.
Yes, my lord. Lordship will kindly come to the next page. On considering the fact that your lawsuit.
So the petitioners are overaged.
Overage. Some, yes, they've been working from.
There is noise coming.
My lord, sorry. Overage, they will be allowed to participate. Ma'am. They will be. Only thing is that in petition number 2307, the advertisement is not for mechanical. These two persons will not be able to participate because the advertisement is not for mechanical engineer. Rest they will all will participate. Even the overage will consider it as per the novel order. All
The
this-
participation has to be subject to their qualification norms.
True, my lord.
Then if that is the reason and they don't allow, then there's nothing wrong about it.
But they have to intimate us, my lord. Advertisement itself, they challenge it advertisement. That is not for
Intimate.
mechanical- for
I had
mechanical.
heard Mr. J. Patwari, learned counsel for the petitioner, also heard Mr. S. Bora, learned counsel.
All the
for the respondents who submit that 2 weeks further time is required to file affidavit in the matter. On the request of Mr. Bora, this matter stands adjourned for 3 weeks, just accordingly. If they don't allow your clients to participate for a reason which is apparently valid, then it's okay.
It's okay, my lord.
Nothing can be done.
But my lord, the last para of that order, which will kindly have the trouble of going to that order once again, last year. 33/2023, my lord. Mr. Asbora will obtain instruction as to whether the post of engineer mechanical which are being held by the petitioners in WPC so and so are also to be filled up by person. Answer is no, my lord. These two are mechanical. Advertisement is not for mechanical. But losses stands to page number 61. It's clear. There is no post.
Let them file affidavit.
Deeply.
Otherwise, it's a contractual matter where contractual employee where a person has been dismissed, your lordship. But I've taken a preliminary objection regarding some document. So my learned friend was supposed to take the instruction from this.
In this regard, there was an application that was submitted to the mission director on 3/2/2020. Regarding that, they have raised objection about the docket number. They have stated that it is a doctored docket number. I have inquired in the office also. I came to know that I have submitted the application, but that is not on the record now. I could not find it in the record, that application. That is, and even without that application, my case can be considered because this is simply representation that has been submitted against the illegal termination.
That's not the case. The issue that we have raised in this regard is that he has
So
said-
you mean to say this matter can be heard without any further affidavit
Yes, lordship.
today itself?
Yes, lordship.
But then it's going for dismissal because if he has come up with an allegation of doctored document and you don't file affidavit, the
Lordship,
only
that-
option for the court is to accept their plea. In which event the writ court cannot grant you any relief.
Lordship, then I will file the affidavit.
Then means just now you said yes.
No, Lord.
You don't
Lordship,
understand the
regarding that, no.
implications.
What I have submitted is that I was asked to take
No,
instruction.
nothing more will be seen. He says the documents you rely upon is doctored. You are asked to obtain instruction. You don't have any instruction.
Lordship, this
You are
document,
just saying, forget it. Let's proceed with the
No.
case. That can't happen.
no, Lordship, because this document that I have submitted,
Hmm.
I am now in a helpless position because I cannot prove this document that I have submitted because I have given it to the office but it is not there in now. I have inquired in the office. I mean, I have submitted in the receipt section. They have given me a
That is
docket,
the reason
docket
I'm
number.
asking you, because if it turns out that the
Lordship,
allegation
then-
of doctored document is correct, then the court will direct
Lordship,
FIR.
That I have
Then you
not
should not pursue this matter at all.
Lordship,
Hmm.
the
We will
document,
take it, we'll have to take it to logical end either this way or that way.
Lordship, because that was in representation, so I may be allowed to submit one representation and let the department be considered on that because this representative that I have submitted, I cannot prove it now. I have submitted in and they have.
And what to do? Court proceedings are all on basis of proof.
Yes, Lordship, that is
And
there.
if you can't prove it, then on the contrary, he is making serious allegations. If we hear the matter and we find that the allegations are not rebutted, FIR against your client straight away. You want to take that risk?
No, Lordship, then
It's not a threat. I'm only saying This is
Yes,
how the
Lordship.
law works out.
Yes, Lordship. I know the position.
The
legal.
allegation is a fraud.
Yes, Lordship.
Fraud allegation, we can brush it out like this.
So Lordship, here what I have submitted was an application.
So you are saying hear it, if you can give me
No.
relief, give me, otherwise I'll withdraw
No,
it, something
Lordship,
like that?
Not, I'm not saying that.
Then
I am saying that, Lordship, I may be given a chance to submit another representation so that at least then I can come with a please.
then you withdraw this writ petition.
So we have liberty to submit one representation here to the department.
Withdrawal part, obviously, I have no question, your lordship. As far as the representation part is concerned, let it fall from your lordship. Let it fall from your lordship. That you-
Nothing, he wants to withdraw with liberty to file representation, we can give it. That is his case, he can do it.
Lordship.
Take down, the writ petitioner is aggrieved by the decision of the authorities not to allow him to continue in the post of skill project manager, bracket human resources and administration. Bracket close, correct.
Yes, Lordship.
Today, when the matter is called up, Mr. S.N. Tamuli, learned counsel for the petitioner, submits that since the copy of the application submitted by the petitioner is not traceable in the record, hence his client be granted leave to withdraw this writ petition with liberty to file a detailed representation before the authorities, inviting their attention to the circumstances of the case, seeking an order in respect thereof. Full stop. Mr. C.S. Hazarika, learned government advocate, Assam, is present.
Lordship, I am for S1 number 3 and 4. Let my learned friend's name be reflected for S1 number 1 and 2.
Ms. A. Talukdar, learned government advocate, Assam, is present for respond numbers
1 and 2.
1 and 2, and Mr. C.S. Hazarika for respond numbers 3 and 4, but do not have any objection if the prayer made by the petitioner is allowed. Full stop. In view of the above, this writ petition stands disposed of on withdrawal with liberty as paid for. Let him file representation. We'll say nothing else.
Item 27.
Wait, please, Lord. My lord, here it is a case where the only question which requires a determination by your lordship is whether a person who is imposed with a penalty of removal from service with superannuation benefit is entitled to leave encashment.
Entitled to?
Leave encashment. To encash the accumulated leave. Now, my lord, here the petitioner was imposed with that penalty. He was provided pension and gratuity. But when he claimed for his accumulated leave of 240 days to be encashed, it was refused. And the order is that later is that you are not entitled to. That is at page 79. Prior to that, my lord may have a look at the punishment. It is a long order. I'm just drawing a lordship to the operative part at 75. Removal from service with superannuation benefit, that is so and gratuity, as would be due otherwise under the rules and regulations prevailing at the time, relevant time, and without disqualification for future employment in terms of clause 6B of memorandum of settlement dated 10/4/2002.
So, but the problem is your name has been shown both for the petitioner and
lord.
the respondent.
I am for the petitioner and the respondent is also represented by another advocate who is also S. Chakraborty. Now, my lord, it is a question of law, my lord. No facts is required because I'll take your lordship to a Supreme Court.
You want today the matter to be finally
If
disposed of,
otherwise, my lord, a person.
not
only-
without them.
Lordship may have a look at the decision. Then if your lordship after going to the decision find that
No, what is, I can't pass an ex parte order in this matter without giving one opportunity.
my lord, the notice was served. I have filed an affidavit of dusty service, on respondent number, my lord. The general manager, respondent number 3, as permitted by this honorable court. And
Where is the service report on 1, 2, 3 and 4?
My lord, the affidavit, I filed one affidavit, my lord, respondent number 3, because I was given the liberty to serve. It is the respondent number 3 who initiated the departmental proceeding, awarded the
And
punishment.
what about 1, 2 and 1, 2
It
and
was
4?
sent by registered post.
But as notice been served.
And she is the lawyer is the engaged bank counsel.
Call her if she's around. Or we'll have it.
I don't have her number, my lord.
Then
Or
we'll
may I
have to-
pray, my lord, the matter may be taken up on 9th, only a small question. And it is settled. Supreme Court examined this
Mr.
issue.
Chakraborty, I counsel for the petition and none is appeared for the respondent. In view of the above, office to list this case again on 13/3/2023 after verifying as to whether service of notice is complete on all the respondents. Or
13th
14/3,
of-
let us have in 14/3. 14/3, 14/3.
13, my lord, 14.
What will happen? You seem to be in a tearing hurry.
My lord.
You just want to get the order, give it to them, get the money and go
No, my
somewhere.
lord, 13, 14, I have some matters in other courts, so it will be,
You will always have matters in courts.
it will clash, my lord. If it is not otherwise inconvenient.
Then
13.
15th. 15th. Mr. Chakraborty, you will always have lot of matters.
No, my lord.
What is,
On some particular days, there are matters, otherwise not so many matters.
what about 15th? Fifteenth suits you? 15th will do something. If possible, if you can find out the other side council.
Today.
What happens is they immediately come and file a review and then, so therefore I am not inclined. Unless sufficient opportunity is given, if I take up expertise, I will pass an order that there is no scope of review.
Right.
I'll shut everything. So it is not that somebody just don't appear, not like that.
Well, otherwise, had it been a case on facts, which requires an answer from them, I would not have heard.
That is a question of argument. The judgment is not on facts on law. The judgment is a judgment. You can't say that this judgment is on facts and this judgment is on law. They can always file a review. This is pecuniary benefit you want. And these orders, you know what happens? People keep running from pillar to post for next remaining part of their life. If you pass an order without hearing them, they will not comply with the order. They will find hundreds of ways to do that. Why would they give you the money which they don't want to give you? So you have to get an order which is technically correct.
Yes.
Understand that. Don't be in a hurry. You get an order, your job is over. But we are concerned about the system.
My lord, the respondent is represented.
That's why
There is a lawyer's name.
we'll
shown
give
and
them
she
a
is not present.
chance. After that, if they don't come, then the lawyer can come and say that somebody was sick in my family. I had to rush to the hospital. Then we'll recall the order.
Definitely.
So for a judge, we have to write out an order. But if it cannot happen again and again,
Obviously.
is it not? So therefore, let us wait and see what happens on 15th. There are holidays in between. 15th will pass some order.
Right.
All right.
For orders, item 28.
Yes, this is a contempt case, Lordship. That order has been complied with.
All right. Heard Mr.
In fact,
Anand
dates
Dehania,
relates to
Learned Counsel for
yesterday's-
the petitioner. Also heard. Mr. Is that matter suspension?
Yes, sir, that's my thought.
Um,
Order is in the next page, Lordship. I have given a copy to him, Lord.
Also heard Mr. P. Nayak, Learned Counsel for the respondents who has produced a copy of the notification dated 1/3/2023 to submit that the order of the court has been complied with. In view of the above, this contempt case stands closed.
Lordship, if your Lordship permits, Lordship, I would like to add just one line, Lordship. Probably before the division bench, Lordship, I failed to convey my submissions, Lordship. In fact, I placed there 7, 8 judgment passed by different high courts. All are division bench judgments and one full bench judgments, Lordship. And the issue in all those judgments was binding nature of Ajay Kumar Chaudhary judgment and its applicability. Views taken by all those judgments, Lordship, is contrary to our high court, Lordship. That is the only.
Why are you not seeking remedy against that? You have not sought your remedy against that. We didn't want to say much.
Lordship, I thought
There is a
probably-
way to seek remedy against that.
Lordship, probably I thought, Lordship, that would be a sufficient reason for having a relook of record would be not. That was the reason.
Seek a remedy. There is a remedy. You are entitled to disagree,
Lordship.
but then you have to follow the procedure. You have to follow the procedure.
Obliged.
That is the only thing here. Of course, there are some areas which may call for reconsideration. But there is a procedure to do this. We can't advise you. As judges, our job is not to advise you. You have good advisors. You are yourself a very competent counsel. You should find your way. What you are asking for was not permissible.
Obliged. Lordship.
Yes, find your way. As judges, we are always open. There is no finality to anything. But your projection is good for you.
Lordship.
It has to impact the judges who are hearing the case. That's where everything depends. You may feel you have a strong point. But what matters is, what is the recourse taken to project that point? That is what matters.
Lordship, I'll-
So nobody has, if you read that judgment, you'll see that the issues have been kept open. That's all.
Obliged. Lordship.
Please, Your Lordship. This is a contempt proceeding, my lord. As per order dated 16/12, my lord. They were supposed to 16/12, my lord. They were supposed to submit the apprise the court for update of their action, my lord.
My lord, we have already sent our file to the finance department for
Now, which is the
endorsement.
order? Let us see first. Which is the order?
Order lordship will find at page 12, my lord. The operating portion at page 15, my lord. In
It's a
the second-
creation of a superannuary post of LDA, my lord, for a period from November
July 11 to-
91 to November 94. To regularize the service, my lord.
So this is the order of December 2021.
21, lordship.
December 2020.
Now, what has happened?
My lord, we have already communicated 2-3 times and finally we have sent a file to the-
Communicated with whom?
to the finance department, my lord. And finally, on 15/12/2022, we have endorsed a file for final endorsement from the finance department for their views, which is yet to receive, my lord.
Finance was not a party.
No, but yeah.
Try your luck somewhere else. I will close the contempt case. Not, this writ petition was not maintainable.
No, my lord, what happened, my lord?
Nothing doing. You want regularization, superannuary post, finance not a party, contempt, question doesn't arise. I have been saying this again and again. They have not taken this plea, otherwise I would have closed this contempt case today itself.
Actually, what happened, my lord, when my petition was written.
Whatever might happen, your client may not know law, but you knew.
I know, my lord, but entire procedure.
All right, so then if they, I will say that the order need not be complied if the finance department does not give concurrence. That's all. How can the biomedia order go and reach out finance? They are not, finance department is not bound to comply with this order. This is our view. You can communicate it. And there will be no complaint. If the administrative department has communicated to the finance, that's all. It is up to them whether they want to comply or not. Beyond that, nothing. These cases cannot be entertained without the finance department as a party. You are just multiplying proceedings before this court. Why did you not implicate the finance as a party?
Because at that time, my lord, entire situation was on the department doing nothing, my lord.
No, this is your wrong understanding of law. You are asking for an order which has financial implications. So in every case, finance is a necessary party, every case, except where it is a case where there is no pecuniary interest. Nothing, changing of nomenclature, these, that. Other than that, every case, finance has to provide for the money. Without asking them, we can't pass these orders without asking for their point of view. These are mistakes which are costly.
Then my lord, I may be given the liberty to file a fresh petition, my lord.
That liberty you take it, but then what happens to your contempt?
The contempt-
Unless, see, soft advices, nobody is bothered. When hard orders come, then the court is harsh. But if we don't do it, the system is going down the drain and nobody is bothered. Nobody is bothered. People are making the mistakes again and again and again. Repeated mistakes. You leave it to the lordship. What is the meaning of leave it to the? How can the finance department be compelled to comply with this order? It is strange that the departmental councils are also not raising this point. None of these orders can be complied with. Administrative department will write to the finance, that is the end of the matter. What can they do? You expect us to proceed against them? Without the finance concurrence, is it permissible? Not a single appointment can be made, single regularization can be made, single promotion can be made, unless it is a cadre post. Unless the finance has to give the money.
Yes, ma'am.
And what is their procedure norms? Whether they have any objection, if so, it has to be dealt with by the court. You don't make the finance a party, you pay the price. You will have to file a writ petition, but not today. When this contempt case will be closed, then you will have to go and file a writ. So see, this hurry makes bari. There is a saying that hurry makes bari. Lawyers are in a hurry. Get some order from the court. These orders keep people running from pillar to post for next 10 years.
Because my lord, at that time, my lord, the petitioner was the age of the retirement, my lord. And we had got the order on the 13th of
So you will
December.
not make
No,
finance.
actually, this is my misunderstanding. I can understand, my lord. I can understand.
So you will not make finance a party. What is the contempt here? Contempt happens when there is willful and deliberate violation.
So
If the finance doesn't give approval, where is the
direction,
contempt?
my lord, by the lordship's order, my lord, direction was directly made to the commissioner secretary of this.
If you
department.
want, I can close it today itself by giving you liberty.
Yes, ma'am.
Or you can do the same thing after.
No. I will not do.
Hmm?
No, I will make the part of the finance department. And now, my lord, so many development has already been happened, my lord. My lord, already they have submitted the proposal to the finance department. After that, filing the writ petition, my lord, after getting the notice, definitely
Finance may still do it because
Yes,
it is
ma'am,
a
I
high
will
court
file
case,
it.
but
Yes, ma'am.
technically it is not correct.
Yes, ma'am.
Your petition should have been either amended or dismissed.
At that time.
By not taking one corrective step today, see the amount of problems we are creating for the future. Nobody wants to look at the future. Nobody wants to do the right thing. Everybody wants quick orders, dispose of representation. See the number of contempt cases that have piled up in the court. As a lawyer, you will be happy. You got some order, give it to your client and he will give you what he has to give you. You are happy. But nobody is bothered about the system. How can these orders be complied with? The departmental authorities will also have to follow the guidelines. The finance department has to make arrangements for the finance. It's not an easy job. And we want them to comply with orders having financial implication without even giving them an opportunity. Is it fair? And who is creating all these things? The counsels for the petitioners. The respondents' counsel are not pointing out these things. The departmental counsels don't even bother to look up who are the respondents, who they are appearing for. In every case, when we ask, who are you appearing for? Then they open the file and ask others, who am I appearing for? These things must change now. Otherwise, it is going to have a bad impact on the system. What I want is young lawyers like you. Young means you are doing good as a lawyer. You also should start thinking about these things.
But then, my lord, liberty may be given, my lord, I will file case and
Wait for another 4 weeks. Let us see what happens. Then we'll see.
Okay.
Mr. D. Bora, Learned Counsel for the petitioner is present. Ms. M. Kotaki, Learned Counsel for the respondent submits that the proposal in terms of the order of this court has been sent to the finance department and a response is awaited. What is to be noted herein that the finance department was not included as a party in the writ petition, but the implementation of the order would undoubtedly require involvement of the finance department. Be that as it may, since the learned counsel for the respondent has sought 4 weeks' time to obtain further instruction, the matter stands adjourned and shall be listed accordingly. In the meantime, you look up, don't take a rash decision. You see what is the remedy possible,
Yes, sir.
apply your mind,
Lordship.
and there is a way out in every case. Only thing is you have to do a little hard work. Do it.
Oblige, Your Lordship.
So anybody for part 2 hearing matters? Mr. Kaur? Sir. You are waiting for some case? Huh? Saika, sorry. You are waiting for some matter? No.
No, madam, I just. I
Mr.
just have to
Bhagwati,
observe this code only, my lord.
waiting for some case? He is there. Which case is yours? Last one. All right, then.